questions?
Madam Attorney General,
Sure.
earlier this month, a bipartisan group of lawmakers on the House Oversight Committee voted to subpoena you to appear for a closed-door deposition. Do you plan? Will you commit to complying with that subpoena and appearing for a closed-door deposition?
I made it crystal clear I will follow the law.
But
Next
does that
question.
mean does that
Next
mean you will
question.
Victim attorneys say that the release of Epstein, identifying of Epstein victims, was one of the single most egregious violations of victim privacy in modern American history. You built your career on being a victim advocate.
Yeah.
Will you apologize to the victims? What do you have to say for that conduct?
Can you explain what you mean by identify? You mean victims' names that were released that shouldn't have been?
Exactly.
Yeah,
and then
so,
also other
yeah,
identifiers.
so under the Epstein Transparency Act, we had 30 days to redact and release, under the law that was passed, 3 million documents. If you stack those up, that's the height of the Eiffel Tower. No other administration, under the Biden administration, they released 0 documents. So we did our very best to comply with the law. And of course, we don't want any victim to be further victimized. And that's why we had 500 attorneys with the Criminal Division, with the National Security Division, with the FBI working around the clock to do the best we could. I think it was less than 1% error. Todd, do you want to add to that?
Yeah, no, that's right. We said from the beginning that any mistakes that were made, and there should be no mistakes. And so when you say lawyers have said something, that's not a fair question, and you know it, because we took pains to protect victims. When someone identified that there was a victim, we immediately pulled that document down, fixed it, and put it back up.
Immediately.
And so of course we don't ever want to do anything to re-victimize anybody that was victimized by the horrible crimes of Mr. Epstein, and we didn't to the extent that mistakes were made, and there were mistakes made because of the reasons the Attorney General just said. But when they were identified to us, we fixed them immediately.
In our first report, we documented the testimony of Attorney General Pam Bondi before the House Judiciary Committee. We showed that her claim that Ghislaine Maxwell was transferred to a same-level facility is contradicted by federal prison classification records. We showed that she could not identify who authorized the transfer. We showed that she deployed whataboutism, deflection, and clock running to avoid answering direct questions under oath. In our second report, we documented the subpoena, issued by Republican Chairman James Comer, signed by members of her own party, a formal legal demand for sworn closed-door testimony, because the voluntary answers she had provided in open session were not sufficient. Tonight, we examine what happened next. The Attorney General of the United States was asked a direct question by a reporter. Do you plan to comply with the subpoena? Her answer was 4 words: I will follow the law. And then, next question. Let us perform a forensic examination of those 4 words. I will follow the law is not an answer to the question that was asked. The question was specific. Do you plan to comply with the subpoena and appear for a closed-door session? That question has a binary answer: yes or no. Will you appear or will you not? I will follow the law answers a different question entirely. It answers a question about general legal compliance. It says nothing about this subpoena, this committee, this closed-door session, or this date. It is the verbal equivalent of a null return. It inputs as an answer but outputs no information. This is not an accident. This is a deliberate rhetorical choice made by someone who has been in legal proceedings long enough to understand exactly what she is doing. She is creating a record of apparent compliance. I said I would follow the law. On camera, in front of reporters, while committing to nothing specific that can be used to compel her to actually appear. And then she said, next question. 2 words that, in this context, carry significant weight. They signal that she considers the matter closed, that the question has been answered, that the reporter who asked it should move on. It is a power move, the rhetorical equivalent of a gavel. The press conference proceeds on her terms, at her pace, and the subpoena question is buried under the next topic before any follow-up can be asked. This is the opening document of tonight's forensic examination. An attorney general under subpoena, asked whether she will comply, who answers with a non-answer and immediately terminates the line of questioning. The remainder of this press conference will show you exactly how that pattern continues. We will now examine the second clip.
And let me be clear on this case. This case has spanned multiple administrations. It started under Bush. It went to Obama. It went to Biden. We were the only, no documents were released, only under the Trump administration. And we released 3 million documents, had 500 attorneys working on that, complying with the law the best we could, and protecting victims in doing it.
Madam Attorney General,
Go
this
ahead.
has been quite an odyssey for you. This began with an encounter you had with some activists in the Roosevelt Room where you handed out some binders. Then there was a discussion, a statement that the FBI and DOJ put out that this investigation was over. Flash ahead to a couple of weeks ago, you had a very unusual appearance before the House Judiciary Committee. Do you have any regrets? Is there anything you might have done differently? And do you think that your comportment and the department's comportment in this have exacerbated the public's lack of trust in this process?
Well, let me repeat what I just said. This has spanned 4 administrations. Bush, Obama, well, Trump won, 45, where Jeffrey Epstein was prosecuted, and then Joe Biden's administration, where 0 documents were provided.
Let us now perform a forensic examination of the statement you just heard. Democrats on the House Oversight Committee walked out of the closed-door briefing. They called it a fake hearing. They stated that its purpose was to allow the Attorney General to avoid appearing for an actual deposition under oath. The Attorney General's response to this accusation was as follows. We were there to answer questions. We came at their convenience. We gave them as much time as they wanted. And then one congresswoman screamed that C-SPAN was not there, and they walked out. Let us apply the evidentiary standard to each of those claims. Claim 1. We were there to answer questions. This claim requires examination in the context of what a closed-door briefing actually is, legally and procedurally, versus what the subpoena demanded. The subpoena issued by Chairman Comer demanded sworn testimony. Sworn testimony means an oath is administered. The witness swears to tell the truth under penalty of perjury. A court reporter is present. A transcript is created. Every statement made by the witness becomes part of a legal record that can be used in future proceedings, including criminal proceedings if the testimony is found to contain knowingly false statements. A closed-door briefing is none of those things. There is no oath. There is no court reporter. There is no formal transcript. There is no penalty of perjury attached to anything the witness says. The witness can state anything she chooses, and if those statements later prove to be false, the legal consequences are effectively 0, because the statements were not made under oath. The Attorney General appeared voluntarily for a briefing. She did not appear under oath. She did not appear under the conditions the subpoena required, and she is now publicly representing that appearance as compliance with her legal obligation to answer questions. It is not. Claim 2. We came at their convenience. We gave them as much time as they wanted. This framing inverts the institutional reality of the situation in a way that requires direct correction. The Attorney General did not appear as a courtesy to the committee. She appeared because a subpoena had been issued, a formal legal instrument signed by the Republican chairman of the committee, and her voluntary appearance was an attempt to satisfy, or at minimum to complicate, that legal demand without submitting to sworn testimony. The timing was not her generosity. The timing was her legal exposure. The day the subpoena was issued, her office announced she would appear. As Congressman Khanna stated in our last report, that is the equivalent of attempting to plea bargain the moment the indictment arrives. Presenting that calculation as an act of cooperative goodwill toward the committee is a misrepresentation of the institutional dynamics of the situation. Claim 3. One congresswoman screamed that C-SPAN was not there, and then they walked out. Let us examine what the Democrats actually stated as their reason for walking out. They stated the briefing was a fake hearing. They stated it was designed to allow Bondi to avoid appearing for a deposition. They stated that without cameras, without an oath, and without a formal transcript, the session provided no accountability, only the appearance of it. The Attorney General reduced this objection to a Congresswoman screaming about C-SPAN. This is reductive in a way that is legally significant. The objection raised by Democratic members was not about camera access for its own sake. It was about the fundamental difference between testimony that carries legal consequences and testimony that does not. A deposition on the record, under oath, before a court reporter, with cameras or without cameras, is a legally binding proceeding. A closed briefing with no oath, no reporter, and no formal record is a conversation. The Democrats objected to the substitution of a conversation for a legally binding proceeding. The Attorney General summarized that objection as she didn't want to ask questions yet because C-SPAN wasn't there. That characterization is not accurate, and its inaccuracy is deliberate. Now, we return to the press conference itself and examine the pattern across the full transcript. When asked whether she would comply with the subpoena, she gave a 4-word non-answer and terminated the question. When asked whether victims of Epstein had suffered an egregious violation of their privacy through the release of their identifying information, she responded with statistics. 3 million documents, 500 attorneys, the height of the Eiffel Tower, less than 1% error rate. She did not answer whether the violation occurred. She did not answer whether victims were harmed. She answered with the scale of the operation, which is not responsive to a question about whether the operation caused specific harm to specific people. When asked whether she had any regrets about her conduct at the Judiciary Committee hearing, she responded by listing how many documents her administration had released compared to the Biden administration. She did not address her conduct. She did not address whether her testimony contained false statements. She did not address whether her behavior, the deflection, the whataboutism, the clock running, the invocation of Irina Zarutka was appropriate for the nation's top law enforcement officer. She pivoted to a comparison with her predecessor. This is a pattern. It has appeared in every public appearance Bondi has made in connection with the Epstein case. The pattern is this. Replace the specific question with a more favorable question. Answer the more favorable question, and move on before the original question can be reintroduced. The specific questions that have not been answered remain on the record. Who authorized the transfer of Ghislaine Maxwell to a minimum security facility she was ineligible for? Who signed the documents that authorized that transfer? Why were interview records relating to an accusation against the President of the United States withheld from the Epstein files release? Why were the names of powerful men identified by survivors in official FBI 302 forms concealed in the released documents? What legal authority was used to justify those redactions? Why did the Attorney General refuse to meet with survivors' representatives who sought to protect victim identities before the release? None of these questions were answered in open testimony. None of these questions were answered in the closed-door briefing, because the briefing carried no oath and no legal obligation to tell the truth. None of these questions were answered at this press conference. And now the Attorney General is characterizing her record on the Epstein case as something she is proud of. The institutional process has one remaining instrument available: the subpoena. Chairman Comer issued it. It demands sworn testimony. The voluntary briefing, the one the Democrats walked out of, does not satisfy its legal requirements. Comer must now decide whether to enforce the subpoena with the same persistence that he has applied to previous oversight investigations, or whether to allow a press conference, a non-sworn briefing, and a 4-word answer to substitute for the testimony the law demands. Congressman Khanna was precise. He said the subpoena must be pursued. He said the questions must be answered under oath. He said the record created under those conditions will haunt her long after she is Attorney General. She knows this. That is why she answered a yes or no question about the subpoena with "I will follow the law." That is why she summarized Democratic objections as a congresswoman screaming about C-SPAN. That is why she ended a press conference about an active subpoena with "Thank you all, have a good night." The oath is still waiting. The subpoena has not been satisfied. The questions have not been answered. We will be here when they are. Stay with us.